Good morning. I would like to start by thanking the organizers for the invitation. It is a privilege to participate in this conference, which brings together an impressively diverse lineup of panels and speakers, and I very much look forward to engaging with all of you over the coming 2 days. As Stuart has noted at the beginning, I have a background in security policies and have focused on the intersection of security policies and international law, with particular focus on international human rights and international humanitarian law. And I do wear more than one hat, and one of those hats is being the legal advisor to the UN Special Rapporteur on Counterterrorism and Human Rights. So I would like to take this opportunity to note the usual caveat, that is that I am making these remarks in my personal capacity, and the views that I am expressing today are not necessarily, do not necessarily represent the views of the mandate of the Special Rapporteur. During today's session, I would like to speak about an issue that has surprisingly become somewhat of a priority, both for the mandate of the Special Rapporteur on Counterterrorism and Human Rights, but also a multitude of human rights actors who deal with terrorism-related issues, namely the human rights implications of tackling terrorist and violent extremist content online, with particular focus on addressing third-party content that can be characterized as terrorist or violent extremist content on social media platforms. And I would like to start with the basics of human rights law and responsibility under international human rights law, which is probably familiar to most of you sitting in the room, but as Stuart mentioned, this is a very diverse crowd with a multidisciplinary background. So this is a point that I would like to make as a starter, and that would be that the primary duty bearers when it comes to ensuring promotion and protection of human rights are states. And states have the duty, on the one hand, to take all feasible, reasonable, and necessary measures to protect persons within their jurisdiction, including from harm coming from third parties. The harm here covers harm to life and physical integrity, as would be relevant in case of a terrorist attack or other kinds of violent attacks, but it also covers unjustified interferences with people's right to privacy, freedom of expression, that may happen, for example, due to corporate activity. And the third parties in question include all sorts of non-state actors, terrorist groups, individual terrorists, as well as private enterprises, as will be relevant for the purposes of today's discussion. On the other hand, states have the obligation, when designing and implementing measures aimed at preventing and countering terrorism and violent extremism, to make sure that all these measures are in compliance with their obligations under international law, in particular international human rights law, international humanitarian law, and refugee law. However, when we are talking about addressing terrorist and violent extremist content online, there is considerable focus on the role of private companies in this regard, despite the fact that they are not the primary duty bearers under international law and international human rights law. And there is particular emphasis on the roles and responsibilities of social media platforms in this regard, addressing both their responsibility under international human rights law, but also under different domestic legal systems. And many people wonder, how did we get here from a very state-focused framework that is international human rights law to a discussion where one of the primary stakeholders that human rights mechanisms are trying to engage being private corporations. And the answer to that is that there has been a very visible shift in recent years linked to efforts aimed at preventing and countering terrorism from offline to online. And this shift was evident First, when looking into how surveillance practices were conducted by states, with surveillance of our electronic devices complementing and even partially replacing traditional special investigative measures and surveillance measures. And measures aimed at regulating and controlling access to online services and content have shortly followed. And the role that private companies play in enabling and facilitating such measures by states cannot be overstated. Internet access providers such as ISPs and telecommunication companies, as well as other companies, have been required by states to institute and maintain total or partial shutdowns of the internet, disruption of communication networks, to employ blocking or filtering technologies, to prevent users from accessing particular websites, platforms, and services, and searching for specific keywords or types of content. In many states, host platforms and others are under a statutory obligation to facilitate access by state authorities to their networks, as well as to communications and content data generated by users. Many jurisdictions, many governments increasingly require direct access to communication networks. So it has become clear that the private sector at this point plays an increasingly substantial role in providing governments with tools and assistance for surveillance and censorship. And in fact, the capacity of states in this regard may depend on the extent to which business enterprises cooperate with or resist such measures. And this resulted in an important change in the role that private companies play in implementing national security policies, including in the area of preventing and countering terrorism and violent extremism. And this shift is perhaps nowhere as visible as in the case of online platforms, and in particular, social media platforms. Why is that? Social media platforms have become, as we all know, the sine qua non of modern life. Billions of people are regular users of one or several such services, and we all have heard or read the staggering numbers reflecting the amount of content generated by users on many of these platforms. Studies also show that people have increasingly been getting their news from social media, and these platforms have been instrumental in disseminating information about political developments at home and abroad, humanitarian crisis, allegations of violations and abuses of human rights committed both by states and non-state actors. And these platforms enable governments to communicate with their constituencies, but similarly facilitate the dissemination of messages by other actors. And their role in facilitating advocacy for political change and even coordinating protest is very well documented. As a result, online platforms and those who provide and facilitate access to them have considerable power in shaping information that is disseminated, meaning that they have de facto authority when it comes to regulating online content. Through this power, these actors can exert significant influence over the individuals and groups' access to information, their freedom of opinion, freedom of expression, freedom of association, as well as interlinked political and public interest processes. The influence of some of the larger platforms far outweighs the power of states in this regard, and it is unprecedented for non-state actors to have such far-reaching and global influence in this area. It is not surprising that in light of these developments, the Supreme Court of the United States has held that access to social media was a constitutional right that was protected under the First Amendment of the US Constitution. Of course, these developments mean that social media has been used and is being used by all sorts of actors and stakeholders for all sorts of purposes. Some of these are legitimate, some of them are clandestine or illegitimate, and this includes, of course, spreading terrorist propaganda, using social media platforms as a tool for recruitment, financing, and planning of operation by terrorist and violent extremist groups. And this development has seen a reaction both in part of tech companies and states. The tech companies have attempted to tackle this problem through coordinated initiatives such as the EU Internet Forum, the GIFCT, the Shared Industry Hash Database, and others, as well as standalone measures, while states have increased the pressure on internet intermediaries and social media platforms to monitor and police on behalf of the state online content that has been generated and disseminated by third parties, by their users. There have been many discussions on the role and responsibilities of relevant platforms lately, in particular their role and responsibility in preventing terrorist and violent extremist incidents. And these discussions have generally intensified in the wake of every single terrorist or violent extremist attack, in particular those perpetrated by individuals linked or inspired by the Islamic State. And an increasing number of policymakers have expressed dissatisfaction with the low efficiency when it comes to monitoring terrorist and violent extremist content by these social media platforms, and have warned them about the need to do more if they want to avoid state intervention through binding regulation and sanction. Most recently, it looks like this is the tendency that many jurisdictions have taken, and there are a number of relevant laws aimed at regulating social media platforms. Before national parliaments, the EU is currently contemplating a draft regulation on online terrorist content, and these laws raised a series of human rights concerns that I would like to flag as follows. And I would like to address three main challenges in this regard. There are many more, but due to time restrictions, of course, I will not have the time to be more comprehensive than that. And the first challenge that I would like to discuss builds on what JM has talked about, namely issues related to the definition of terrorism and violent extremism. Secondly, I would like to address the conditions under which speech may or even should be restricted. And I would like to advance thirdly some thoughts on the role and responsibilities of private companies and states in this regard, and how these responsibilities should be divided, and what are the areas where we need further thinking and constructive developments in order to efficiently tackle the issue of terrorist and violent extremist content. Now, if we start with dilemmas relating to the definition of terrorism and violent extremism, I would like to address this issue from the point of view of international law, and note at the outset that definitions under different disciplines can be quite different. So please note that when I'm talking about what terrorism, what are the elements of terrorism should be under international law, I am strictly focusing on the legal definition. As JM has noted, there is no internationally accepted definition of terrorism, and this poses a very important problem, a very important shortcoming, as the cornerstone of all counterterrorism policies is an adequate definition and an internationally accepted definition of terrorism, having in mind that terrorism in general is not, or it is rarely a domestic phenomenon. It is frequently a transborder or an international phenomenon, and especially when we're addressing the need to counter terrorist content online, we definitely deal with situations involving a multitude of jurisdictions. And the lack of a confined and accepted definition of terrorism also tends to undermine the efficiency of counterterrorism measures, both at the domestic, regional, and international level, as relevant resources will be used to target conduct that could efficiently dealt with outside of the counterterrorism framework. There are 19 different terrorism-related conventions that have been adopted under the umbrella of the United Nations. And as noted, none of these offer a generic definition of the crime of terrorism. There is also a draft convention, a comprehensive convention on international terrorism, that has been stuck in the 6th Committee of the UN General Assembly for a very long time and is likely to stay there, probably until Kingdom comes. There is no expectation that there is going to be considerable progress on that draft. However, this does not mean that most of the elements of the crime of terrorism under international law are not crystallized. They are. The reason why the draft treaty definition is controversial relates to 2 issues. One of them is whether a state and state-armed forces can be perpetrators of terrorist acts, and the other is whether terrorism can be committed in pursuance of the right of self-determination. These are the issues that are unlikely to be solved anytime soon. However, when it comes to the crime of terrorism, the elements that are internationally recognized to constitute elements of the crime of terrorism are the following. We are talking about acts that cause death, serious bodily injury, or other serious harm, as defined in international conventions and protocols relating to terrorism, and they are perpetrated with a special intent, and this means either the intent to terrorize or seriously intimidate the general population or a segment of it, or with the intent to unlawfully compel a government or an international organization to do something or to abstain from doing something. As you will note, this definition does not contain any mentioning of ideological, political, religious, and so on, motivation as a component, as an element. And this is because while motivation is a very useful category for political scientists and for other disciplines when studying the phenomenon of terrorism, they are less helpful for lawyers because they introduce a subjective element that could open the door to abusive or discretionary implementation. And for this reason, neither the draft comprehensive convention nor the definition of terrorism adopted by the United Nations Security Council include the motivation as a constitutive element of the definition of terrorism. Now, while the main elements of the crime of terrorism are arguably well established under international law, if one looks at the different definitions adopted by individual states in their domestic law, we will find that these definitions vary, and they vary widely. Many states took the internationally accepted, arguably accepted definition, these elements that I listed before, as a de minimis standard and adopted definitions that are a lot broader than the crime that I described before. And this unfortunately led to many jurisdictions using terrorism definitions and related legislation and policies to target civil society, journalists, political opposition, different minority groups, and so on. However, even countries that have a more confined general definition of terrorism frequently end up adopting overly broad definitions of preparatory and ancillary offenses, such as material support to terrorism, and very broad offenses criminalizing speech, such as advocacy of terrorism, glorification of terrorism, apology, praise, or justification of terrorism. And these offenses attach criminal sanctions frequently to conduct that falls short of incitement to terrorism or advocacy of national, racial, or religious hatred, which are categories that are accepted under international law and that have known definitions that states could use in this respect. In fact, if we look at the prosecution statistics related to support and glorification or apology of terrorism, we find that frequently it is the not-so-usual suspects who come within the scope of such regulation, including, as mentioned, journalists who report on government overreach, members of political opposition groups, but also teenagers who posted something dumb and ill-advised on social media, mentioning one or the other terrorist group, or even persons who mentioned the Islamic State while drunkenly cursing at police officers arresting them. These are actual cases that have been prosecuted in domestic jurisdictions and where people have been convicted of glorification or apology of terrorism for conduct that may have been ill-advised, that may have been widely questionable, but it is not convincing that this conduct should be dealt with actually as terrorist offenses. And as already addressed in quite some detail by JM, laws and policies addressing violent extremism similarly raise definitional concerns. Even more so, while there is some components of terrorism under international law, we cannot say anything similar with respect to extremism, violent extremism, or radicalization. These notions are prominently present in current political discourse at international, regional, and domestic levels, but none of these actually have agreed definitions. And many of the relevant definitions that one can find in domestic systems are policy definitions, not legal definitions, because governments realized that the definitions that they have advanced would not comply with their obligations under international human rights law, in particular with their obligations relating to freedom of opinion and freedom of expression. These definitions have been criticized for being vague and at times encompassing manifestations that are lawful under international human rights law, and they have been frequently used to suppress views that deviate from the social norms accepted by the majority under the guise of preventing extremism. And these measures may target thought, belief, and opinion rather than actual conduct. This is particularly worrisome in case related measures are not accompanied by robust safeguards, which again tends to be the case. Since we're talking about online content and terrorism and violent extremism as it manifests online, due to the non-territorial nature of cyberspace and of the internet, the impact of local laws and policies frequently reaches beyond the territory of the state that has enacted them and that is enforcing them, and potentially impacts the human rights and fundamental rights of individuals that are not within the respective state's jurisdiction, which obviously causes for additional concerns. Moreover, when it comes to social media platforms who have to deal with all these different types of domestic laws and regulations, in particular, the larger platforms operate in multiple jurisdictions, perhaps in 100+ jurisdictions, and the discrepancies between these different domestic frameworks inevitably raise difficulties for the platforms. And it is frequently impossible for them to comply with all these different regulations in their operations. This is why many of the platforms have come up with their own definition of terrorism or terrorist entities. And this is, again, a development that may raise a number of concerns under human rights law. On the one hand, one may ask, should a private actor have a definition of terrorism that it enforces on its platform, thereby taking up tasks that traditionally have been described as government or public interest tasks? And of course, as these private platforms do not have formal obligations under international law, the definitions adopted by them frequently do not reflect international standards, which raises another concern. Obviously, one could argue, and I would argue, that ideally, private platforms, social media platforms, should not have their own definitions of terrorism. But in the current context, it is very difficult to fault these social media platforms for devising their own definitions, aiming at some level of certainty, having in mind the fragmented regulatory landscape that they are confronted with and that they have to navigate. Now, this leads me to the next point that I would like to address, which focuses on when intervention and when restrictions on speech are warranted or even required. Human rights law standards and built-in flexibilities inherent to human rights law provide answers to these questions. And I would like to very briefly outline the human rights standards when it comes to regulating speech online and offline. The starting point is that freedom of opinion under human rights law is absolute. However, freedom of expression is not. And this means that speech, including on social media platforms, can, under certain circumstances, be limited in pursuance with a legitimate aim, which under human rights law includes national security, public order, and the rights and freedoms of others. And the measures taken in this respect need to be necessary, need to be able to actually achieve the legitimate aim that is pursued, and they need to be proportionate to this aim. Before we start censoring content, there is, however, one additional aspect that we need to keep in mind, and that is that freedom of expression under human rights law doesn't only protect speech that others find agreeable, but it also extends to speech that offends, shocks, and disturbs, and that tolerance of such speech has been described by a number of stakeholders, including by the European Court of Human Rights, as a bedrock of a democratic society. Now, states and generally duty bearers under international law do have an obligation to remove and to censor certain kinds of speech. And I would like to note two examples in this respect. One would be what is usually called as hate speech. The long name is advocacy of national, racial, or religious hatred that constitutes incitement to discrimination, hostility, or violence. But to save time, I would just refer to it as hate speech. And hate speech is described as an intentional act that causes for a reasonable probability that this particular expression would succeed in inciting hate crimes, and therefore establishes a degree of causal link or an actual risk of a hate crime or this prescribed result occurring. In case such speech, in case of such expression, both states and arguably also private platforms do have an obligation to remove and to filter such speech. And the second category that I would like to mention is incitement to terrorism, which in some ways is actually in its element very similar to hate speech. Speech that amounts to incitement to terrorism is speech that directly or indirectly advocates for the commission of terrorist offenses. And the main commonality with hate speech is that it advocates for the commission of terrorist acts in a manner that it causes a danger that one or more such offenses may actually be committed. These standards, both the general limitations on speech, restricting hate speech, and incitement to terrorism, provide for the necessary tools for addressing online content, including content that may amount to incitement to terrorism, glorification of terrorism, or violent extremist content. But the question still remains, how do we address the role to be played in this respect by states and private companies in designing and in implementing the relevant frameworks? And this brings me to the final set of questions that I would like to address, namely the roles and responsibilities and the division of responsibilities between states and private companies. As I noted briefly, from an international law point of view, non-state actors, including companies, are not formally bound by international covenants, including human rights treaties, and this means that they do not have any formal obligations under international human rights law. Their conduct under international law is governed by the United Nations Guiding Principles on Business and Human Rights, which provide an authoritative global standard for preventing and addressing adverse human rights impacts linked to business activities. And while these guiding principles have been endorsed by the Human Rights Council and the General Assembly, they are not formally legally binding. They are being recognized, accepted, and implemented by a growing number of private companies, however, so they are particularly relevant for the purposes of this discussion. In accordance with the UN Guiding Principles, the extent of the responsibility of a private company, of a private entity, depends on the actual role and influence that they exert, which in case of large social media companies warrants a particular role and quite a high threshold of responsibility. Because as, on the one hand, as mentioned earlier, they exercise control over online freedom of expression and access to information of a large number of people, despite being privately owned and operated. They have quasi-legislative, quasi-executive, and quasi-adjudicative power when it comes to regulating access to and the use of their platforms. They set their own rules of engagement in the forms of terms of service and community standards, and they interpret and enforce these. So from the point of view of human rights law, there are two ways of making sure that these online spaces remain spaces where the human rights, including freedom of expression and other interlinked rights of users, are protected. And these two options are either self-regulation, roughly speaking, self-regulation by social media companies, meaning that they voluntarily accept international human rights standards and strive towards implementing those standards when it comes to access to and use of their platforms. Or the second option is enforcement of human rights protection and promotion by states who do have formal human rights obligations and must protect persons from unwarranted interference, including when these people use social media platforms. Now, both of these options bring challenges, and the ideal result would probably be a mix of the two, co-regulation, a mix of self-regulation and regulation by states. What I think we should keep in mind, and this will be my concluding thoughts, what we should keep in mind moving forward are two aspects relating to regulating social media content. And one of these is that, as mentioned, the internet is global, and many of these social media platforms are either global or present in a number of countries. And at this point, the regulation that we're dealing with is most of the time local, domestic, and therefore fragmented, and as such cannot really provide the answers that we need if we aim to keep the internet a place that facilitates freedom of expression, access to information, and a space that also facilitates public interest discourse. So in case we would like to efficiently tackle these issues, we would need global standards and global regulation. And the second aspect that we need to keep in mind is future-proofing these regulations and policies. Quite a few of the challenges that we are facing today are linked to the fact that relevant processes and policies have not been developed with human rights in mind, with the importance of protecting freedom of expression, with the importance of protecting freedom of association, public interest discourse, public interest speech on these platforms. And once you have very intricate and very complex processes developed, and you try to add human rights protection, you try to add freedom of expression and other rights as an afterthought, this leads to considerable challenges, and it may be very difficult or even impossible to properly implement. So for this reason, I would like to stress these two aspects: the global nature of regulation that we need, and the need to think in advance and to future-proof whatever rules and standards we come with in order to safeguard the internet as a free space conducive to public interest discussions and discourse. Thank you very much. I look forward to questions and the discussion with all of you.